Hi, my name's Aidan Lurch and I'm an Associate Overseas Practitioner at Floyd Zadkovich in the London office. I'm here to talk to you today about how cross-examination in international arbitration is entirely different from cross-examination conducted in common law legal systems like the United States, England and Wales, and Australia. Cross-examination is an important legal technique that can be used in international arbitrations to achieve a good result. Importantly, however, it is very different to the type of cross-examination conducted in common law legal systems. An international arbitration is generally not tried before a decision maker from the same country as legal counsel. Instead, the decision maker is either a sole arbitrator or a panel of arbitrators who will usually be three highly experienced lawyers, often from three different legal and cultural systems. Therefore, each arbitrator will not necessarily be positioned to favour the gung-ho style of cross-examination often found in the American legal system. Now, before the hearing starts, the parties will have exchanged with each other and submitted to the arbitrators extensive evidentiary material, including written witness statements. The arbitrators will then study this material with considerable care. They will have a detailed understanding before the main hearing starts of the issues in dispute. As a result, the arbitrators will evaluate the cross-examination undertaken at the hearing against the background of their detailed understanding of the issues, and that will significantly impact counsel's freedom in how they examine a witness. It means that during cross-examination, counsel cannot necessarily go on a field trip exploring any legal or factual issue they deem to be relevant. Lengthy cross-examinations will not be very convincing to arbitrators who are well versed in the detail of the matter. Instead, cross-examination must be succinct and efficient, and directed to the specific issues in contest. Another factor that complicates the examination of witnesses is that generally no national rules of evidence will apply in an international arbitration unless the parties have agreed otherwise. Arbitrators are likely to be considerably more liberal in admitting evidence than a national court would be, as they have both the right and the duty to evaluate evidence freely. What this means is that fundamental legal principles which are found in common law legal systems have no place in international arbitrations. For example, there is a sacred principle outlined in English and Australian law known as the rule in Brown and Dunn. It holds that where a party intends to lead evidence that will contradict or challenge the evidence of an opponent's witness, it must be put in the course of cross-examination. This principle will have no relevance in an international arbitration. Cross-examination must therefore be modified to take into account that the fundamental rules of evidence will not apply. Another interesting feature of international arbitration is that while the burden of proof rests with the parties, arbitration panel members can ask their own questions of witnesses to ensure that they have a clear understanding of the relevant issues and facts. Cross-examiners must therefore ask their questions fairly and ensure that the witness understands their questions rather than intentionally confusing the witness. Legal counsel could otherwise embarrass themselves if an arbitrator later clarifies a position with a witness. All in all, while cross-examination conducted in international arbitration is certainly useful and has a place, it is entirely different from the way in which it is conducted in common law legal systems. That's all from me today, and if you have any questions or queries, feel free to ask anybody from the team at Floyd Zadkovich or zeiler.partners.